Hi, everyone. We're just going to get started in a minute here. We'll let folks hop on and then we'll get going with our program today. All right. Hi, everybody. Good afternoon. Thanks for joining us. There are still folks filling in, but we'll get going here. My name is Naina Gupta. I'm the policy director at the American Immigration Council, and I'm so grateful to be joined by three fantastic experts for our web briefing today on immigration detention in this alarming moment. Before we get started, I just want to name a few logistical and administrative items for all of you. Today's web briefing will be recorded. So if there's information that you miss, you'll have a link to this. You'll be able to share it with colleagues. Anybody who registered for this web briefing will receive a link to this after our program, in addition to follow-up resources. We have a Q&A function that you'll see at the bottom of your screen. You can use that to type in questions through the course of our presentation. Our experts will graciously respond to some of those live with time we have at the end, and we'll do our best to answer others in writing. Just as a friendly reminder for those of you who join us regularly for these, we cannot answer questions about specific cases or specific people that either you're representing or that are unrepresented. We can't offer that legal advice, but we're of course happy to share resources and other information that we have that might be useful. And with that, I think we can dive in. Our briefing today: ICE detention, 59,000, record levels, horrible overcrowding, dwindling due process. Again, I'm joined by three experts: Aaron Reichland-Melnick, a senior fellow here at the Council, Becca Wolf, who's the director of our Immigrant Justice Campaign, and Karla Ostolaza, managing director of immigration practice at the Bronx Defenders. So in April, the Trump administration announced that it had a goal of deporting 1 million people annually. But senior officials acknowledged that the government's insufficient detention capacity posed a constraint to those plans. The United States would have to hold hundreds of thousands of non-citizens while they awaited removal proceedings and process for deportation, given these numbers announced by the administration. At the time of Trump's election, ICE's budget was approximately $9.6 billion, which was sufficient funding to hold about 41,000 people in the immigration detention system. But by June, ICE and DHS was reporting holding nearly 59,000 people in detention, the largest number in recent history. So in a matter of months, the admin increased the system's capacity by 150%, raising alarm bells about a strained system. We've seen mistaken deportations, deteriorating detention conditions, and a lack of basic due process, including decreased access to counsel and decreased access to avenues to make a case for release for people inside. And our experts today will speak more to these policies and shifts. As detention has ballooned, facilities have become increasingly overcrowded, and reports of the abuses that are already endemic to the system long before Trump have worsened. Detainees in the Chrome Detention Center in Florida reporting a hellish environment with 60 to 80 adults jammed in a single room and people forced to sleep next to toilets being used by other people in detention. We've seen ICE increasingly use holding cells in their field offices, which are designed only to hold people for a few hours at a time, but the agency leaving people there for days without giving them food. In one instance, a young woman reached out to a national news agency in desperation. Her brother had been stuck in a facility with a 2-week-long severe eye infection. The woman passed along images sent by her brother of his eyes nearly swollen shut. The facility had refused to give him medication despite multiple requests and his worsening medical condition. Given dozens of reports like this around the country and more than 10 publicly reported deaths of people in ICE custody in just 6 months, members of Congress have made surprise visits to immigration detention facilities, only to be turned away in violation of their legal rights. When one congressional member made a surprise visit to the Chrome facility I just mentioned in May, after two men inside had died, she was allowed in and shared that the facility already held nearly 300 more people than it was designed to hold. Attorneys, human rights observers, and members of Congress, including most recently the office of Senator Ossoff of Georgia, have reported facilities around the country facing similar overcrowding and extremely abusive conditions, including lack of adequate gynecological care for pregnant women, insufficient insulin provision for diabetes patients, starvation, and other severe medical abuse. Now, DHS has long used private prison companies to manage and run a large portion of the US immigration detention system. At the start of the second Trump administration, over 90% of people in the system were already in facilities run by private companies like CoreCivic or Geo Group. But in April, new contracts initiated by DHS with private companies revealed immediate plans to add up to 60,000 detention beds in facilities across the country. And now the ongoing expansion of the system will be supercharged under the Reconciliation Spending Bill, the big, beautiful Bill Act signed into law by President Trump, which allocates an additional and unprecedented $45 billion for building new facilities. This is a 308% increase on ICE's most recent detention budget. And with this funding, we estimate at the council that ICE will likely increase detention to 125,000 people or higher, making the system comparable to the entire federal prison system. In the past month, we've seen announcements of several new facilities around the country. Aaron, in a moment, will talk us through, who's running those facilities, what they look like. We've heard states like Indiana and Nebraska offering their facilities to be used for detention using dehumanizing alliterative titles to name those locations. We've also heard announcements from the administration to use military bases, in particular Fort Bliss in Texas, to detain thousands of more people. Who are the people inside these facilities? Karla and Becca will help us get a better understanding of that given their work. But we have heard over and over again from this administration justifications of these increasing numbers in terms of public safety. But the reality is that only around 30% of people in immigration detention at this time have criminal convictions, and the vast majority pose no public safety threat. We've seen people with lawful status, DACA recipients, even US citizens swept into detention alongside many others, including asylum seekers and longtime residents waiting for their immigration court hearings. Before I turn it over to Aaron, who will talk more about the specific new policies we've been seeing from the Trump administration that impact the detention system and the people inside, I just want to step back to make a couple of quick points and reminders on the nuts and bolts of detention for those who may be less familiar with it. Immigration law has long and always authorized the government to incarcerate non-citizens who are in violation of civil immigration law before their immigration proceedings begin and while they proceed. For some, there is a right under immigration law to a bond determination where they can make a case for release, showing that they pose no public safety threat and no flight risk. In these cases, both the Department of Homeland Security and immigration judges have the authority to release somebody from detention. But as we will learn both from Becca and Karla, that practice is increasingly less and essentially non-existent under this administration. Over time, though, we've also seen an expansion of the number of people who are subject to mandatory detention, which means they have no statutory right to a bond hearing to make a case for release. This is in stark contrast to the criminal legal system, where even those accused of serious violent crimes have a right to a bail hearing. And unlike the criminal legal system, in the immigration detention system, the presumption is one of detention, that the burden to prove that somebody should be released is put onto the non-citizen, despite the fact that this is a system with no right to an appointed lawyer. With those facts in mind, I want to turn to you, Aaron, to walk us through the host of new policies we've seen from this administration that impact people inside and the system before we turn to Karla and Becca to hear more about what we're seeing around the country.
Thank you, Naina. So as Naina laid out, the current immigration detention system is one that has been in place for many years, but is being supercharged under the Trump administration. I want to walk through a few policy changes that the Trump administration itself has made that is leading to more people being held in detention and different people being held in detention. And then I'm going to walk through how that is actually playing out in practice and give you some data on what this looks like, how many people are being detained, and how many people are being arrested in those shifts. So first, on January 20th, day one, President Trump issued an executive order entitled Securing Our Borders. And under this executive order, President Trump declared that it is the official policy of the US government to, quote, detain to the maximum extent authorized by law aliens apprehended on suspicion of violating federal or state law until such time as they are removed from the United States. So the very first thing that Trump did on taking office was sign an executive order stating that all immigrants who are being held on violations of immigration law should be detained. That became very quickly grounds for more people being arrested, detained, and sent to immigration. And within the first month or two, the Trump administration began stopping normal policies of release and humanitarian parole that had been occurring in detention, even during his first term in office. Then on March 7th, the Trump administration began reopening family detention centers in Karnes and Dilley in South Texas, and which would begin the process of reinstating family detention previously ended under President Biden that had been in place really since before then, from President Obama through President Trump's first term. That was the biggest changes in policies, but then on May 15th, the Board of Immigration Appeals, which is the appellate body that sits over the immigration courts, had a say as well. That board had been purged by the Trump administration soon after he took office, with half a dozen Board of Immigration Appeals members that were hired under the Biden administration, all immediately fired or laid off in the first few months that he took office. Then on May 15th, the Board of Immigration and Appeals, in a decision known as Q. Lee, ruled that any migrant arrested at the southern border or arrested on entry into the United States was now mandatory detention, regardless of whether or not those individuals had been initially released with a notice to appear or even granted humanitarian parole or conditional parole after passing a credible fear interview. So this narrowed the pool of people who were eligible for release and meant that more people had to be held in detention. Then, most recently, on July 8th, Todd Lyons, the acting director of ICE, issued a memo directing ICE to argue in immigration court that any person who entered the country without inspection, so that's people who crossed the border, was categorically ineligible for release on bond. This overturned decades of practice, finding that those people, unless they had a disqualifying criminal conviction, were eligible for bond. But even more concerning, the Trump administration's ICE worked with the immigration courts, and some judges were pressured to start to change their interpretations of the law, even though no precedent had come down changing this, meaning that many people, potentially millions of people, who are in the country after having crossed the southern border without inspection, many of whom have no criminal record, were suddenly, if subject to an arrest, ineligible for release on bond and not able to even ask a judge. Now, legal challenges continue over these, but what this looks like in practice means that, as you'll hear from Karla and Becca, people who are fighting their case in immigration court have less access to bond than at any point in the last few decades. So how has this played out on the ground? Well, give me 1 second, and I'm just going to switch over really quickly to some slides showing what this has actually looked like. 1 second. So, who is carrying out these arrests? Well, one major thing the Trump administration did on taking office was deputize thousands of federal law enforcement agents to carry out immigration arrests. At least 6,700, according to a chart prepared by the Niskanen Center, have been deputized from various other parts of the government. And this chart doesn't even include CBP officers, Customs and Border Protection officers, including Border Patrol agents that are now doing interior enforcement. ICE, Homeland Security Investigations, the criminal arm of ICE that normally goes after drug traffickers and child exploitation and other crimes online, has been told that their primary mission must now be immigration enforcement. Over 4,000 Department of Justice law enforcement officers, including 2,000 from the ATF and 2,000 from the FBI, DEA, and US Marshals, have been reassigned to immigration enforcement. So that's over 4,000 in total from the DOJ. 600 officers from the State Department's diplomatic security services, who normally protect foreign diplomats, have been made to do immigration enforcement. 250 IRS tax enforcers are doing it, and even more. We've heard even the US Postal Inspection Service police has been diverted to doing immigration enforcement. So what's the result of this? A major increase in ICE arrests. Specifically, this is data that was released through something known as the Deportation Data Project. And what it shows is daily arrests under the months before Trump and now what's happened since. As you can see, after he took office, there was a massive surge in arrests. And we also started to see a major increase in arrests of people with no criminal convictions, because this data is broken down by people who have some violent offense, any prior criminal history at all. That includes things like traffic offenses or immigration offenses, people who face pending charges, and people who have never been charged with a crime whatsoever. And so you can see for the first few months, it was a huge increase, but it was a stable increase. For about 3 months straight, ICE arrests didn't increase dramatically. So the White House began pressuring ICE to hit numbers higher. At first, they aimed for 1,000 arrests a day, and then in late May, the White House sent out a demand: you need to hit 3,000 arrests a day. And what happened was ICE changed who they were arresting and began arresting people at immigration courts and at ICE check-ins, the lowest hanging fruit possible, people who were complying with ICE and were being re-arrested. And this population was overwhelmingly people with no criminal convictions or no criminal charges whatsoever. So beginning in June, at the end of May and going into June, we saw a dramatic increase in the arrests of people with no criminal convictions, while the arrests of those who do have some sort of convictions remained flat and stable and have continued as such. In fact, have even dropped a little bit. So as of today, the largest population of people that ICE is arresting and sending to detention are people with no criminal record. This has also changed who is being detained. This chart here is 6 years of data on who is in detention by what agency arrested them. The dark green at the bottom is people arrested primarily at the border by US Border Patrol. These are mainly migrants and had been for many years, for a decade. The majority of people in detention were people arrested at the border. Well, that's changing. As border numbers are down, the Trump admin is sending more and more people to detention who have been arrested in the interior. And they are sending more and more people to detention who have no criminal record. In fact, really starting in April, we started seeing this red line here. This red population is people with no criminal record at all. These are people arrested by ICE in the interior and sent to detention. And that population is growing and growing. And so as of today, there are more people in detention that were arrested by ICE who have no criminal record than people in detention who were arrested by ICE and have pending criminal charges. The first time this has ever been the case. And that is the major shift as we've hit near 60,000. These latest data, which ends through August 12th, shows that we were at 59,000, over 59,200 people. And according to the New York Times, when ICE's data next comes down, it will be over 60,000. That ICE has hit this 60,000 number. Of course, they want to go further, and we'll talk more about this later. But now I want to move to Becca Wolf, who is going to hand it back over to Nana to transition to our next guest.
Thanks so much, Erin, for walking us through those numbers and policy changes. So yes, I'm thrilled to hand it over to Rebecca Wolf, who's the director of our Immigrant Justice Campaign here at the Council. Becca, it would be great to just hear from you what the impact of these policy changes have been across the system, and especially what you're seeing in terms of access to counsel given IJC's work.
Thanks, Nana. Thanks, everyone, for joining. Again, I'm Becca Wolf. The Immigration Justice Campaign is the arm of the council that does direct representation through a pool of volunteers all over the country. So our information and experience is from clients who are detained anywhere from Louisiana, New Mexico, California, everywhere. And there's some really, really disturbing national trends, as Nana and Erin have both sort of started to talk about. And one of the things that Erin pointed to is that the conditions of detention in the interior have started to model and then even surpass the conditions in detention that were always in existence in border communities. Detention facilities along the southern border with Mexico had been notorious, have been notorious for overcrowding and for deteriorating conditions for quite some time. What is happening now is that is being internalized. Detention centers all over the country are seeing the same conditions and new conditions as well. So Nana alluded to this. Overcrowding in particular is one of the biggest issues. And I think that sometimes we don't really know what that means, what overcrowding is doing. In addition to things like people being crowded into Chrome, for example, and sleeping on the floor, there have also been reports in the media and by our own clients of a lack of food, a restriction on food that is being distributed to people in detention, and spoiled food, lack of basic medical care. So in addition to things like medical care for pregnant women, we had a policy once to not detain pregnant women. That is no longer the case. But also people that are having seizures in detention without and waiting hours for medical response. People, we have clients who are not being given their antipsychotic medication regularly. We have clients who have diabetes, who are not having their diabetes treated, chronic conditions that, when left untreated, can cause irreversible harm. We're also seeing, again, lack of bed space. And what that means in real life is not just that people are overcrowded. It means that people are sleeping on the floors, in the hallways. And as Nana mentioned, in facilities that are not set up to be long-term detention facilities at all. And the other impact of overcrowding is that the immigration courts are being slowed down. So people who used to be detained for 5 or 6 months through the pendency of their proceedings are now being detained in many cases over a year. And so that, combined with the lack of release from detention, is putting enormous pressure on people in detention to give up on their cases and return to countries that they have fled from, or return, quote unquote, to countries that they have not been to since they were 4 or 5 years old. One of those policies of sort of restriction on release from detention actually is impacted by a policy under the Biden administration. The Biden administration, in their attempts to sort of restrict the border and be tough on the border, implemented a rule that made a lot of people ineligible for asylum. So they're eligible for other kinds of relief, called withholding of removal or protection under the Convention Against Torture, but they are by policy, by rule, ineligible for asylum. So we have people who are being granted relief. The judge is granting relief, saying, yes, we cannot, you have established that you have been persecuted in your home country. You've established that if you are returned to your country, you will be tortured or face persecution. They are not eligible for asylum because of a rule that was put in place by the Biden administration. And what is happening now is that up until 6 or 8 months ago, people who were granted withholding of removal or CAT were released once they were granted, released into the United States. They have permission to be here. That's what the grant means, is that we can't send them back to their home country. And it was pretty common, a pretty common practice. Right now, what the government is doing is saying that they will not release any of those people. And so people are winning their court cases and continuing to remain detained. This is connected to the third country removal policy of trying to remove people to third countries, although many of these people are not actually being removed to third countries. They are just being held in detention indefinitely. I'll just sort of also say, and Karla's going to speak more to this, one of the things that has happened is that because of this mass overcrowding, and a total breakdown of oversight entities that used to, at least in theory, be called on to address complaints of conditions in detention. People are being moved from detention center to detention center across the country. And while that has, again, historically was fairly common along the border, people being moved from New York to Louisiana has incredible implications for people, not only because for lawyers, they're being moved from circuit to circuit. So the law changes depending on where they're detained, but people are being moved away from their legal counsel. They're waiting even longer for court cases. And it's just compounding the problem with the conditions in detention as a whole. I think I'll turn it back to Naina with that, and happy to answer questions at the end.
Thanks so much, Becca. That was so helpful, particularly, building that connect between the overcrowding we're seeing and the coercive nature of those conditions for people accepting removal, even when they have cases to fight. Just the past few weeks, we've heard reports out of the Everglades facility run by Florida that they're calling Alligator Alcatraz, where there are folks who've been pushed into accepting voluntary departure and the conditions being used in an extremely coercive way, but also the trends you highlighted about what this means for the immigration courts, given the numbers of people we're seeing inside. So with that in mind, I want to turn to you, Karla. You're also, working across the country representing people in facilities who are being moved around in the way that Becca described. If you want to jump in to just share what you've seen as an impact of some of these policies and changes we've laid out, that would be great.
Thank you so much, Nina.
And sorry, I should say that Karla is joining us from the Bronx Defenders.
Thank you so much, and thanks everyone for joining. I'm the managing director of the immigration practice at the Bronx Defenders, and our team co-runs the first defense public defender program for detained immigrants in deportation proceedings. So our staff and our programs cover 100% of people who are detained at the very extreme immigration court, which is the immigration court for detained people in New York City. So everyone who doesn't have an attorney and wants an attorney and is deportation proceeding gets an attorney from our program. We also have a lot of clients from New York City who are detained in Pennsylvania or New Jersey and whose cases are vented in New Jersey. So we're seeing a lot of these changes in real time, and it really has impacted our ability to meet with our clients, aside from the devastating human implications. So I just want to run through some of the things that we're seeing specifically in New York, because all these practices have a little different flavor region by region. And in New York, the focus has been redetention at immigration court and at check-ins. I think that's where the bulk of the detention is happening. And it's important to note that the primary immigration court for non-detained cases is in the same building where the ICE check-ins happen and where they have the temporary hold facility, which is not really temporary. They're putting people there in this black box basically for days and days, sometimes weeks. So a lot of people are going into court to have their case heard or are going to their check-ins and are being detained without any justification, any reason, any change in their circumstances. So for example, we have just last week, we had a client who was released earlier last year from immigration detention. He's a lawful permanent resident who is the primary caretaker to his wife, who is a terminal cancer patient. He was released from detention by ICE back in May of last year because they determined he's not a danger to the community, because they determined he's not a flight risk, and because of the role he plays in his family. Nothing in his circumstances have changed other than he happened to have a check-in and there's a new administration. And also his wife is sicker and more in need of help. He was detained, he was given no explanation other than this is Trump. Now we are going to detain you. And we see stories like that every day of people, of our clients, some of our clients being also threatened with detention, even if it hasn't happened yet. It's a looming fear because they're being harassed and asked to go back to their check-ins more frequently. And I'm talking about people who might have one relief, but it's a form of relief that is not full status. So they have the ability to bring people back into check-ins, but they have been out for 20 years and they have been checking in whenever they're asked to check in. And now all of a sudden they're being asked to go every 3 months and have more intensive surveillance or have ankle monitors. So that's one of the things we're seeing. In terms of the detentions in court, we're seeing basically, no matter what happens with a person's case, they might be detained when they step out of the courtroom. And just walking into that courthouse in the 26th Federal Plaza in Manhattan is terrifying. It's the environment of fear, and the hallways are lined with ICE officers wearing full face coverings. You can only see their eyes. They're walking around, surveilling all the courtrooms. And we see people being detained after their case is dismissed because they're going to be placed in expedited removal, but also after they get an adjournment to find an attorney, or after they are set up for a hearing for the asylum claim, or after their order removed, but they have said that they want to appeal that decision. It doesn't matter what happened in the case or who the person is really, they could be detained, leaving the courtroom. And then they're just disappearing into the system sometimes. They get detained for many days in this whole facility. We have been turned down a request to communicate with people in there to offer our services, or for our own clients after they're detained in check-ins, because they all go to the same whole place and we just can't communicate with them. And then they sometimes are transferred into our area, but sometimes are moved to the other side of the country and to some courts where don't allow for remote appearances. So there's no way we can actually represent someone in those circumstances. As with strained resources as a nonprofit, traveling for every court hearing will be untenable at any scale. So we're seeing. Also, I wanted to know, everyone detained in New York City is detained while at liberty, because we don't have because of our sanctuary cities, our city doesn't collaborate with ICE. So ICE is not allowed to go into a jail and detain someone who's still in their criminal process at any point. Everyone who's detained is someone who has been found, even if they had a criminal case at some point, they have been found that they should be released and that detention is not appropriate in their case. And ICE is supposed to make an individualized assessment whenever they encounter someone and they're thinking about detaining them, whether the person is a danger to the community or a flight risk, if the person is bond eligible, and that is not happening. And we've been litigating that since Trump won. We have an ongoing case because they have a blanket no release policy. So the only way for people to get released is by asking a judge to review their case, or sometimes by filing a federal lawsuit in district court. And many people once they are able to secure a bond hearing, they can establish that they shouldn't be detained, but sometimes that can take a month, 2 months. And in the meantime, their families or their lives just completely crumble. We represent a 20-year-old high schooler who was detained at his court appearance, and it took a month and 2 organizations litigating in 2 different venues, federal court, immigration court, just to be able to get him out on bond. And that's not something that most people will have the luxury to afford. And I'll leave it there and happy to answer questions.
Thanks, Karla. That was incredibly helpful. Just, I think highlighting the differences, as you say, regionally and what's happening. I think in places like New York, where there are policies, the way we're seeing the agency work around sanctuary protections to nevertheless detain people without due process. Also, this pattern of courthouse arrests and apprehensions leading directly to detention. Is another kind of trend that we've seen already in 6 months. So, given what you've described and Becca has described about transfers and conditions and lack of access to counsel and to bond hearings, Erin, I want to turn back to you for just a couple more minutes. As I said at the top, we're now looking at DHS having a significant more amount of money to expand this operation and system. So maybe you can tell us a little bit more about those dollars and how we can expect them to be spent. We also have some questions from audience members about, whether this amount of money is in addition to what the agency already had going into this, and where those numbers fit in.
Thank you. So we've been talking a lot about what has happened and what is happening. So I wanted to switch over now to a little bit about what is to come and what we know of the administration's plans and what Congress has just given ICE for detention in the latest big budget bill, the so-called One Big Beautiful Bill Act, H.R. 1. And so I'm going to very quickly switch back to show a slide where we have information about that the Washington Post has put together that really shows a really excellent look at what is to come here. This is a map put together by the Washington Post last week showing what facilities are currently active and what facilities are set to open. It is ICE's plan to hit 100,000 people in detention on an average daily population by the end of the year. It's not clear if they're going to be able to meet that, but they have the money to do it. And they have the money to do it thanks to the reconciliation bill, which gave ICE $45 billion to be spent through the end of fiscal year 2029. So by September 30th, 2029. That averages out to over $10 billion a year on average more. And that's money that goes on top of the $3.4 billion that ICE currently gets in funding every single year for detention, a sum that may even increase. So we may be looking at an ICE annual detention budget upwards of $13 to $14 billion a year. That is higher than ICE's entire current annual budget, which is $10 billion. And they will have this money for the next 4 years. We can see that they intend to expand detention throughout the country, not just in the South, not just in places like Texas and Louisiana, but in Oklahoma, in North Carolina, in Virginia, in Indiana, in Colorado, in California. And they're going to do so not only with new facilities that they are going to construct, usually so-called soft-sided facilities like the Everglades detention camp that Governor DeSantis built, but by contracts with pre-existing jails through the expansion of 287G programs and more. So what we are looking at in the next 3.5 years of the Trump administration is tens of billions of dollars spent to expand detention to the highest level that it has ever been in US history. And this is just the start. This is what they intend to do by the end of this year, but there is more to come. With the money that ICE gets, as we estimate, they will be able to have at least 116,000 people in detention, and depending on how they spend the money, could easily hit 125,000 people should they seek to expand more. And beyond that, Congress also gave $3.5 billion to state and local governments that want to build their own detention centers or otherwise spend money cooperating with ICE. And as we've already seen, Florida is doing this and other states are following along. So we may have facilities operated by state governments that are holding people for ICE. We already have those in some cases, but now we have not had before custom-built facilities, soft-sided detention centers, tent camps built for people in detention. And tent camps are the future of detention. Soon, ICE is going to max out the facilities that can be used for permanent infrastructure, pre-existing prisons, and we'll be having to build new facilities, like is happening in Fort Bliss in El Paso, Texas, where ICE is intending to open the largest immigration detention center in the country, potentially holding anywhere from 3,000 to 5,000 people at any given time, all in tents, not in permanent infrastructure. So we are going to keep an eye on this at the council going forward. And with that, I want to transition back to Nena, who can talk through some Q&A and where we go from here.
Thanks so much, Erin, Becca, Karla. We have a whole host of really great substantive questions. So I'm just going to dive in. We've been trying to answer in the Q&A some of these in writing, but wanted to tee a few up live. So maybe first we can turn to you, Becca. Somebody writes that, they've seen DHS citing to Section 235 of the INA to argue that immigration judges do not have jurisdiction in bond proceedings. And in this person's jurisdiction, DHS keeps reserving appeals and people in detention continue to be detained even when they are granted bond. And this person wants to know if we know of any Board of Immigration Appeals or Circuit Court of Appeals recent decisions that speak to this issue.
Yeah, so I think there's sort of a couple of issues here. One is the appealing of the grant of bond. So this is used to be very, very rare, but has been happening a lot. And also there's an intersecting issue where ICE in some cases has refused to process bond. So ICE processes people paying the bond, like physically processes that. And ICE in some cases has refused to process the bond even when it's granted. There are not any that I know of BIA or circuit court decisions that have fully addressed this issue yet. It's also fairly new, relatively speaking, for a case to get through to a circuit court. There have been some challenges under habeas petitions in a number of jurisdictions that don't go directly to this issue, but where certain circuits are addressing the fact that you can't have de facto mandatory detention by the whim of ICE, that ICE choosing or deciding to appeal a bond should not, in effect, subject that person to mandatory detention. I think the other thing to talk about is that there's actually two problems with Section 235 that have been raised, and one is what Nena mentioned in terms of QLE, which is case law, and one that is sort of what I think Erin mentioned, which is a declaration to EOIR that this is how we now interpret the statute. And so those need to be dealt with differently, and I'm happy to share resources afterwards. We have been pretty successful in winning bonds in some situations in front of some judges, so it's not all, the cause is not totally lost.
Thanks so much, Becca, for laying out the two issues there. And I want to turn now to you, Karla, maybe just for a little bit more of some nuts and bolts. We have a couple of questions from folks about where and when detention is being ordered. Is it at hearings? When does it happen? So maybe you could help kind of highlight for us the different points in the removal process where people are being detained.
Yes, absolutely. So typically people are detained and then placed in removal proceedings. What we're seeing right now is that a lot of people have been put in removal proceedings, either never detained or just briefly detained and released at the border, for example. But now they are re-detaining people, and they could be in any stage of their process. Sometimes we see people who are at the very beginning of filing, of starting their immigration removal defense part of the case. Let's say they just file an application for asylum or another benefit with the immigration court, and they're just leaving court. They get an adjournment to come back another day to fight their case. They're detained. We're seeing people who are also perhaps like after their trial, maybe they lost or they're waiting for a decision, they also get detained at that point. They can also be detained just not in court, but waiting in between court hearings, court dates. They have a check-in with ICE, and then they're detained at that point. So we really are seeing people detained at every point of their immigration case, including people who don't have also immigration cases anymore, whose cases might have been dismissed or terminated based on discretion or because they have a form of relief outside of immigration court, like a U visa, for example, for people who have been a victim of a crime and they have cooperated with the investigation. Some people have been detained while they have this application pending and they're going to a check-in, even though they don't have a deportation case against them anymore.
Thanks, Karla. That was really comprehensive, which is also just reflective of all the points at which somebody can be detained in this process. I want to turn back to Becca. Becca, we had a question from somebody regarding, who profits off this system. We mentioned at the top that going into this administration, 90% of people were already in facilities run by private companies. So if you could say more about that, and then, as a follow-up, someone asked, are states and counties supporting, local jails with resources? And I'll just put one added point here. We have an explainer on detention that also goes into this that we'll make sure to share with everybody after today.
Yeah, so there are 3 major private prison corporations that run the majority of privately owned immigration detention centers, and quite frankly, also a lot of privately owned criminal detention centers. CoreCivic, GEO, as Nina mentioned, and MTC is the third. And even when they don't own a facility, they often have contracts with the government to manage the facilities. And so it is an incredibly profitable business. There were some reports at the very beginning of the administration, and in fact, a lot of reporting during the first Trump administration about the profit margin for these companies and how much money they're making. To the question of, and so shareholders are profiting off of this essentially. The other question, though, about county jails and city jails is an important and interesting one. Karla talked about the fact that New York City has a sanctuary law. Other cities do too, and sometimes those laws prohibit contracting between a county or a city and using their jails. But when places like California attempted to pass a law prohibiting any coordination of sort of subcontracting or contracting out facilities by the counties or cities with ICE, that was actually overturned for states' rights reasons, for various reasons. So counties and cities can profit or make money, profit's probably the wrong word, but can make money and income for their city or county by contracting with ICE. ICE pays those jails and those counties to house people in their jails. And so part of what Erin is talking about in terms of the current expansion is, yes, building new detention centers, but also contracting with new county jails. We had clients who were moved from the Denver area to Wyoming in a county jail 2 hours away from any city center. And rural counties, have financial issues that makes this appealing. And so, but this is also a place where people can really advocate locally and take on issues locally in your own communities. Cities and counties can be told not to renew contracts with ICE and can be pressured to not sign new contracts with ICE or the federal government to house immigration detainees. And that has been successful in a number of places. Just wanted to add a little, there is something out there that people can do.
So helpful. Thanks, Becca. And yeah, I mean, an increasingly complex web of contracts and who's running what facilities and where dollars are flowing. I know in the past I've had an opportunity to attend public shareholder calls for some of these private facilities where you'll actually see, line graphs of the more number of people detained, the higher their profits, to really underscore the way profit is tied to the number of people in detention. I want to turn to you, Erin, with a question that came from one of our audience members. With all the building of these new detention facilities, what plans does the administration have for the use of these buildings, the infrastructure, when they run out of people to fill those centers? So if you could talk maybe a bit about how facilities get repurposed, carceral facilities across different systems.
Yeah, and I think this builds a lot on what we just talked about with private prisons, because a lot of the facilities that the Trump administration has been bringing online, these permanent infrastructure facilities, pre-existing facilities, are private prisons that the federal government stopped using under President Biden. A number of federal prisons were essentially deactivated when the Biden administration stopped using them for Bureau of Prisons detention. And then that left these facilities essentially as empty jails. Now we are seeing these facilities brought back online and used for ICE instead. Some of that was actually already happening under the Biden administration, where President Biden, on one hand, stopped using private prisons for criminal detention, but on the other, expanded the use of private prisons for immigration detention. But the other aspect of this is these soft-sided facilities, these tent camps. And they are entirely operated as well by contractors. They are constructed by contractors, staffed by contractors, maintained by contractors. They are not actually operated and owned by the federal government. And so what that means is eventually, when the money runs out, which it might if Congress doesn't reauthorize it in 4 years, those facilities would be dismantled. I don't think, obviously that said, the more permanent prisons are built, the larger the operation goes. It does create an incentive for other people to be sent there. It creates an incentive for these companies to sell their services to others, to shift over back to the Bureau of Prisons. And I think we are seeing a large scale growth in the detention infrastructure that is there. And even when the money runs out, it will also put a lot of incentive in Congress to keep the money running, because local economies will suffer. And you see this consistently where small communities where prisons are built will expand them and want more people there to take more prisoners, to take more detainees, to keep the local economy running. So as much as I would love to say the minute the money runs out, all of these facilities shut down, I don't think that's going to be the case. I think some of them are going to be used for other purposes, or their very existence will lead Congress to appropriate even more and more money on an annual basis to keeping these places running.
Thanks, Erin, for some real talk on that. Karla, I want to turn to you. There's a question from an audience member about, what you are seeing and if you are seeing people being re-detained after they've been released on bond, and what your experience has been with that and the clients you represent.
We're not seeing a massive number of people being re-detained after a grant of bond by a judge, but we are seeing some of those, and we have heard certain indications from ICE that this will happen more often based on technical violations. So, for example, we represent someone who had basically a desk appearance ticket that was dismissed before, was never docketed. It was never the prosecutor didn't want to go forward with it, but ICE decided to bring in the person, and they indicated that they can and will be canceling bond based on those violations, even if nothing happened with the criminal case, and that they also can and will be revoking bond for people who are asked to go back and they missed their appointment.
Thanks, Karla. That's really helpful. We're going to take one more question and I can get us started, but then Becca and Karla, please jump in with anything I miss or added thoughts. We have a question about, we keep hearing that immigrants have due process rights in the immigration system, but what are the differences between those rights as compared to the criminal legal system? And so just to get us started, it is absolutely true that the Fifth Amendment, generally speaking, applies to non-citizens, but the core set of rights, particularly procedural rights given to immigrants in the civil immigration system, are far less than those offered in the criminal legal system. The first and foremost being that, of course, in the criminal system, there is a right to an appointed lawyer for everybody, regardless of any kind of citizenship status, and that is not the case in the immigration system. But beyond that, in immigration court proceedings, there are no federal rules of evidence that dictate how parties litigate a case in determining whether or not somebody receives the punitive consequence of detention or deportation. There is no Sixth Amendment right to confront an accuser. So police reports get entered regularly into immigration court proceedings, but would be considered hearsay evidence in a criminal proceeding. These kinds of procedural protections and what evidence can be introduced and how an attorney or an immigrant facing removal can respond and refute those allegations, those rights are abrogated in the immigration system. But Becca, I don't know if you want to add, from your work, how you see some of that, lack of due process play out.
Yeah, I mean, and there's also this sort of perhaps too far in the weeds issue of some immigrants, depending on their status of how they've come into the country, are afforded fewer due process rights than others, because when people come into the country and are put directly into detention, we have this legal myth that those people have not yet entered the United States for the purposes of some due process rights. So it's very in the weeds, but it is a distinction. I think that you've hit most of them. I think that one of the things that is really critical is that people in detention are also far more likely to not be represented by counsel. And so those rights that they do have to fundamental fairness and procedural due process can only be asserted by attorneys in many cases. And so the limitations on access to legal counsel directly impacts sort of how due process works in real life. But I'm sure Karla has some more sort of specific examples.
Yeah, I mean, piggybacking on that, what we're seeing in terms of court detentions in New York City is that the people who are the most likely, overwhelmingly the most likely to be detained, are those who appear without an attorney. For people appearing with an attorney, they're magically never in the list of ICE to be detained. And I think what the government is looking right now is for really efficient deportation, which means deportation without due process or any fight. And attorneys make that really hard. So they're trying to find all the ways to avoid access and also trying to deport people who are not already engaged with attorneys.
Can I
Thanks
just
so
add really
much.
quickly? I'm so sorry. I was just going to add, because it's kind of astounding to what Karla was just saying. The ways in which the government is restricting access to counsel is unprecedented. Things as simple as being able to find your client, be able to file fees, being able to file applications, all of that has been dismantled or severely restricted. And so not to put too much of a doomsday attitude on it, but it is getting harder and harder to get that counsel.
No, thanks, Becca, for making that clear, like where we're seeing kind of devolving due process already from the low level of due process that we've had in this system for a long time. Maybe to pivot us a bit away from doomsday into some like action items as we wrap up here in our last couple minutes. For any of you who are not on our Immigrant Justice Campaign listserv, we encourage you to sign up. That is a list where Becca's team and the council, regularly offer actual take actions that folks can participate in to push back on what we're seeing in this system. We'll share a link in the chat so you can join that, and you'll be hearing from us in the next few weeks about specific items you can engage on. We encourage you to reach out to elected officials at the state level and federal level to look up, what facilities in your state, in your city, in your county are supporting the detention of immigrants, and to talk to your elected officials about these abuses and violations of due process that you're seeing. We will follow up with resources on the system, a toolkit for any staffers that are joining from elected officials' offices so that you can help your bosses ask the right oversight questions in this context. And we hope to stay in touch with you all. And again, we will send a link of the recording of today's briefing so you can share that with colleagues. And a big, big thank you to Karla and Becca and Erin for wading us through this complexity today. Thanks so much.